Hi, I'm back. I think this might be a record for me for like going live or having a little go like for like at least 2 whole weeks in a row. Just saying. Again, the chat's not showing up. It's so weird. It's kind of last minute, and I noticed there's a ton of people live. I just can't. You can't coordinate around everybody. I can't. I be like polite, but that's usually why I don't end up going live. It's like, oh, they're on, and then by the time like they're like, because I want to watch, because I'm more of a consumer than a creator. I don't even consider myself a creator at all. I'm just a lady I'm not in a closet anymore. I can't believe people thought I was actually in a bathroom for so long. Like nobody gave me shit about being in a bathroom going live. I was actually in a closet, but I had a shower curtain behind me. So I get it. And then that one night I posted a live of like uh coming out of the closet. People were like, oh my gosh, what? She's coming out. And it was just like I think it's titled like Behind the Curtain. Yeah, behind the curtain. So it was just kind of like this is just me, just a live chat, like whatever. And I named it Behind the Curtain. And people were like coming like, oh, good, you have clue. Like, and I still didn't get it because they thought like behind my shower curtain was my bathtub. Gonna be going live from my and I still didn't get it. Some things just I'm like my dad that way. Some things just fly right over my head. Hey, Pumping Vinyl. Good to see you here, sir. Jerry, Professor Pug, Redneck Zilla, good old Jeff with two F's. I think I saw Delphi Dummies here. Hello, sir. And Hippie. Hi. CJK. Hello. Good evening. And I'm going to pick up where we left off. I know I got there at the end. I got totally just, off on a rabbit trail. And then Tom Webster joined me. I still don't know how, but I was so glad he did. That was such a nice surprise. And of course, it was like at the end of the show. And then I was like just so excited because I just adore him. I think he's awesome. And so for him, that was like such a nice surprise. And then I was up until I don't even know. I think it was like 3 o'clock in the morning. I had to work today. So that sucked. But I was just like too like hyped up. You like my shirt? Yeah, I guess I'm kind of on a theme here. I didn't even realize. Oh, no, I'm gonna have to fix that. I just took off my work clothes and put this on. I can see them, the hanger nipples. That's gonna bug me. But yeah, I wore Colts yesterday and then IU today. My daughter went there, so she got me this, and it's like nice summer sweatshirt. It's not too hot, but I love my sweatshirts. Hey, Melissa. Hey, CJK. I think I said hi to you, but if I didn't, hello again. Yeah, I don't know if this is the one she bought me or she bought herself and I stole it from her. So, probably the latter. I wear my daughter's hand-me-downs. I don't like new clothes. I have like skin issues. But I don't like to like shop at certain places because I have germ issues as well. I'm just letting myself all out here tonight. I don't even know. I need to shut up. You know what I should do is I should have like an intro so it keeps me from just like randomly babbling until my nerves calm down. I know, Hippie, that was so cool. But I've been trying to figure out how he did it because I don't know. And I feel like I should know that. But it was awesome that it was him and, like, not somebody, like, that I wouldn't allow on my show. But he's welcome anytime. Him and quite a few others are just like, "Hey, I have an open invitation here," but some people definitely do not. I know. It was a total magic trick because he's like the YouTube badass award goes to him, so I don't know. I should email him and just ask him because I try to figure it out. Like, I'm thinking I have heard people talking about how you can just, join StreamYards, but, I mean, I got this StreamYard for a couple years, so I still don't know how to work it. I'm late because I I was hidden behind the picture, and I couldn't figure out how to do that. I did that with Burn After Reading too. I'm like, "Where are we?" He's like, "I don't know. It's just a picture." Like, I'm like, "Oh my gosh." So, yeah, I hopefully this microphone is okay 'cause StreamYard did send me a bunch of things because I asked them for help, and they sent me a bunch of things to try to help me out, but does it sound okay before I go start reading from my Google Doc? Mic check, mic check. It seems okay. I got out my old one, but I'm gonna follow StreamYard's, list of things I can try with my nice mic, see if I can get it fixed. Because 'cause I'm really hoping it's not the mic. Really hoping it's not my mic. Thank you. Buy a cup of joe on me, please. Aw, thank you, Professor Pug. That's very nice of you. We need to catch up soon. I feel like I haven't talked to you in, if it's been a month, it's been too long. Okay, let's go. Share this, like and subscribe, all the things that I never try to do to help myself out. It'd be great though. I'd really appreciate it. I know these are boring, but I really do try to keep my opinion separate from just the case so I don't feel comfortable editing out. Like I felt even of just cutting the motions down to just the topic that we're talking about, which is the digital forensic, like that I wasn't, doing it right because I'm not reading the entire document. So, but we're doing a comparison, we're going through from March all the way until recently. And today was just filed. Let's go ahead and talk about that for a few minutes before we get going. Hey, Cher. So glad you're here. I see your comments. Um, so I didn't read it because again, I've been at work, but Frank Meister and he sent it to me, we were messaging back and forth, and I'm just like, how in the hell? So the defense wants the jury, they want to go to the scenes of the crime. I would think that they would want to go to the two separate scenes and probably all the way, to I don't know what you would call that, like to his car, so all the way down the trail. They can't go across the bridge, but they could go and view everything from where he parked, go down the one section of the trail, go to where the bridge is now blocked off. And then they would have to go get back in a vehicle, a bus or something, because you got to remember there's 12 jurors and then there's alternates. And I've seen juries with 4 alternates and 2 alternates in Indiana. So I'm not sure. I'm guessing that they're going to have at least 4. for a trial that's lasting this long. But and then the 2 parties and the judge and then all the security, I'm pretty sure the public, like, even the public that attends are not gonna be able to go. I'm not sure about, like, media, I don't know. But, they could do that, then they're gonna have to take the bus to the private drive, and then they're gonna have to view the other side of the bridge from that angle. And then they would have, in order to actually see the whole crime scene and, like, the crime scene flow, they're gonna have to walk down from the hill, from the bridge to the private drive, down to the little meadowy part area, and then surely they're not gonna march them across the creek. So then they're gonna have to go back up there. What would they do after that? Possibly take the bus over to the cemetery and then park over there, and then, go down that hill to the crime scene area in order to see it all. I don't see how that's logistically possible. Um, I don't know, maybe like a live drone or a person, with a camera on, obviously a professional, with like a live feed for the jury to be able to see. I don't know. I don't know what the answer is. And I don't know. I don't know if I really don't think Judge Gull's gonna say no outright. Because I think that I think the state wants to get this jury to see, like, and to think that it's impossible. But if they're all capable of doing it, when we know that a ton of people have gone out here and done this, so we know it can be done in even a shorter amount of time than he had. Like, just the getting there, just the hiking part alone, take out the crime of it. Um, to me, it's not that hard a terrain. It's just really not. Like, obviously, there's parts where if you step wrong, you're going down, but it's, I don't even think I, was, like, breathless. But then again, my cousin who was with me was, but she doesn't hike. So, I guess there's that perspective too of, and when I go hiking, there's nothing more that I hate worse than a trail. Like, I like to find, like, a deer path or, something off. Hiking to me is not walking on a gravel or paved trail. That's not hiking in the woods. And then I do it with all the races. So there's that perspective too. Some people it's very difficult. Some people it's like, really? Especially if you've hiked out of state or in any kind of mountainous area at all. It's not difficult. But I think what they're mainly wanting to disprove, well, I don't know, is maybe what Cicero had said about the purpose of the sticks did, um, hide their body from the opposite side of the creek. But I don't know how I feel about that. I think the sticks are definitely odd, and I don't know what they mean. Do I think they're runes? No. No, I don't. I really don't. I mean, um but they're weird. They're weird, and you would think, okay, say that, you know, he hears someone and he's interrupted with like covering them up. Why wouldn't one girl be you would work on one girl at a time? Or why would you pull them into an area that's like kind of a tiny, it's not a big clearing by any means, but it is kind of a tiny clearing. So I don't think that was the purpose. I don't think it's a human sacrifice to the Norse gods, but I don't think that the sticks lack meaning. They don't mean anything to me, they don't mean anything to you, but they mean something to the killer. Like, I truly do believe that. But I think they wanna disprove that. They wanna disprove the time that he wouldn't have this one man wouldn't have been able to do this, control 2 girls with this terrain, and I think that is important for a jury to see, to be honest, but I do think that it's gonna backfire on him. I don't know if and Rosie and Ajer, what is it? I need, like, a prompt. OJ, yeah, because Aju is French dip sauce, right? OJ. Okay. Have they been out there? I don't know. I think it's gonna backfire. Which, will he go? Will Richard Allen be made to go? Okay. Um, I know, me too. I think that's gonna backfire too. Hasn't it already? Like, I feel like it's back, especially after these hearings that just took place. Even now we have, we don't have all of the transcripts, but we have some of them, and even still, the the sensationalism, the, like, 2 people viewing these same things in a completely different way has not curbed any kind of activity at all, not allowing cameras in the courtroom, and we know that Carroll County has the system in. And we also know now that they approved buying, and everybody thinks like, oh my God. And when you first hear a podium that costs $70,000, but of course, you know how I think I probably spent an hour too long researching these podiums. There's like a couple companies out there that this is what they do. And they are like 70 grand is kind of in a middle range price for one of these things. And then, because I do watch I watch trials all the time live. And now in like just since looking into this $70,000 Carroll County podium, I've seen them. I took screenshots of them in different courtrooms. Like they are a thing, and they have all the bells and whistles on them, like they're pretty freaking cool. And systems like this also, like the live feeds already that they're already installed. They had to because of COVID. That was one of the things with COVID. So, but she said that she allowed them in the Allen County courtroom because they're more set up for that kind of thing, and she's right, they are. Um, but that the media that was given access to I think it's called a closed circuit, like live, that they could all use that same live, that they misused it, and that's why she was like, they can, that's I lost faith in the media, so I'm not gonna be we're not having camp. And this was a while ago. I just didn't read that one. Good night, Professor Pug. Oh, yeah. But the creek is one of those things too, is I don't know. We have a creek that's very similar to it by my house, and I mean not so much anymore, like although I would love to, but it's a little weird for a grown lady to be playing in the creek. And then I found out some things about the creek water, and then I was like, I can't. But we used to do that, like creek stomping. There's a few, like every place I've ever gone with my kids, we've done that. And like, it would depend on how high the water is. And then also like when you go out there, there's like, I don't know what they call them, but basically like areas of Deer Creek where you could get a kayak or a flat bottom boat through there, no problem. But depending on the water height, there's some places where you're gonna have to pick that up and, you know, move it to the other side of that. And like in that area, there is one of those, and I know that from the search the next day, you kinda see in some areas, but not in others because of the terrain of the actual creek. So, that's a consideration too of, like, there's times when I've been out there when I was younger, and I don't know, I feel like when we went out there when I was younger, the creek was was like, "This really isn't a river," 'cause I feel like it used to be a lot higher than it has been post 2017, like, historically, I don't know that for a fact, but I feel like when we went there for, ugh, I always forget the name of them because it was with the homeschool group, field trips, um, it was like it was bigger. I don't know, um and then you can kinda tell from the trees too that at some point the water was at, like, this level on some of these trees, so but it's kind of a floodplain right there. So I don't know, but I've gone out there once and the water was really low. You could just, be if you were wearing hiking boots, they're not gonna get, you'll be fine. And then other times you're like, "Holy crap." The one time I went, the water was high and the current was really pretty powerful. And I know this because there was a deer and a baby doe that were trying to cross this creek. It was such a I mean, we both just we sat down and just watched this because it was just so beautiful to see because we were so close to this, um, doe and like this deer and her little baby, and they were trying to cross from the bridge, like the private drive side, the deer and her baby. And my cousin is hitting me because she's behind me and she's like, oh my God, like look. And we look over and we just sat still and just sat there and she videotaped it. I didn't. And yeah, we just watched them. They were swimming in the current, like the mom was keeping her baby from, floating down the stream and then to watch them get up on the bank. This was more over by that weird fence area that Ron Logan had up. You could just climb right over it though, but this happened with the deers more that way, and they were kind of coming from the angle of more of the house on the private drive, and then they're swimming across the creek in kind of an angle, and then they came up right there on kind of a steeper part of the bank. So that was, something to me too of this deer and her baby had trouble, this is a deer too, getting up this part of the bank. And I'm just I think people have the crime scene wrong. And this was a long time ago. And then eventually when we found out where it was, I was right about that. And by us going way beyond the fence, um, that ended up being where they were actually found. We just didn't know that information when I had gone out there. But, hey, Frank, good live tonight. Yeah, so like I said, no, I can't see a jury being made to cross it. It'd be I don't think that's gonna happen. It is beautiful out there. And I'd heard so many people, because I've been going out there since I was little, what else do you do when you're homeschooled? We went on field trips all the time. Never mind the schooling, whatever. That's a whole nother story. But, that whole area is historical, Riley, James, what is it? James Whitcomb Riley? the poet slash, oh, what was he also? I want to say explorer, but I don't think that's the right word. But that's where the banks of Deer Creek, that's where that song comes from, and then, like, most of the houses along there are that part of the historical society, like, it's, early settlers. It's a great place to go to find arrowheads. That's been a known thing for many, many decades, but, yeah, Delphi is pretty central to Indiana as far as settlement of this state. So, okay, I'm gonna get started. Okay. So, if you haven't watched the 2 prior to this, you're gonna be you're about a month behind on the back and forth between the defense and the state as far as what I've been covering here tonight. So, we're just gonna jump in and chat. If anyone has questions, they don't know what we're doing, you can let them know if you've been here. Okay, so on May 20th of 2024, the defendants, this is their second motion to dismiss based on newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. So they're wanting to get the whole case dismissed. So, and again, this is a filing that has a lot more in it. All I did was simply word search and find keywords that had to do with digital forensics. So the prosecution failed to turn over one of the key pieces of evidence for nearly 9 months, and then only after the defense kept requesting the prosecution for the same. A key piece of evidence in this case is the phone data extracted from victim Liberty German's phone. The prosecution and law enforcement had possession of evidence for 5 years prior to Richard Allen's arrest, and therefore should have been able to provide that evidence immediately to the defense. However, the defense did not receive that evidence until September 8th of 2023, almost 9 months later than required under criminal rule. And that is correct. But again, anyone studies case law, there's always a loophole. Even when things you think are concrete, you find out very quickly that they're not. However, the defense did not receive the evidence until, I already read that. After the defense had a chance to review said data from the phone, it was determined that exculpatory evidence existed in the phone that did not support law enforcement's timeline and supports that third-party suspects were involved in the murders. The failure of law enforcement to turn over Liberty German's phone for nearly 9 months, thereby concealing exculpatory evidence the defense could have been exploring from the beginning of their representation, is further evidence of intentionally in attempting to conceal evidence and or evidence of bad faith. Now, remember what we read in the prior 2 episodes of this little this digital forensics deep dive here, about these things. And the first Franks, which we didn't talk about on any of these lives, but the first, and then, I mean, they were mentioning BH and these other people before they thought that this evidence is exculpatory. This phone thing of her phone pinging at 4:33 a.m. So I don't know. Just, that's not like a feeling. That's just this is timeline stuff. Law enforcement concealed the Blocher report until April 26th of 2024. The state of Indiana turned over the report from Steve Mullen concerning the findings of Sergeant Mitch Blocher of the Indiana State Police. Contained in the body of that report was exculpatory information that supports that on February 13th of 2017, the victims were not located at the same scene as they were found on February 14th, 2017. Later, I should highlight this for myself. The failure of law enforcement in turning over this report for well over 1 year beyond when the prosecution was required to turn it over, and only after the defense sent a certified letter and filed a motion to compel and for sanctions, demanding that the prosecutor turn over certain evidence, is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith. Bad faith is a pretty common thing. The state wasn't able to present a case that the leak, even though even with Westerman being charged, and don't ask me, I don't know what's going on with that case. I haven't followed it. And Baldwin, admitting it, they still weren't able to prove bad faith, and they didn't at the hearings that they held for that. So both sides of the bar is pretty high for proving bad faith on either side. That's all I'm saying. This is June 9th of 2024. So this is the state's response to the defense's second motion to dismiss. The state did not intentionally delay providing the extraction data from Liberty German's phone, nor did the state conceal exculpatory evidence from said phone. I underline things when I hope I've tried to throughout these of have a color code and a underline thing in my head of not intent, dismissive words used, or just this is a fact, or there's a word possibly or might have, did not intentionally, words like that, and because that's just lawyering talk. But I underlined things that I wanted to go back through and compare with what they've said over a course of time. The state did not conceal a report involving documented. So that's kind of a definitive statement there. So you can kind of see the difference. Involving documented communication between Carroll County Prosecutor's Office investigator Steve Mullen and Indiana State Police Trooper Blocher. Nor is the information in the communication in any way exculpatory or even potentially useful. So again, a definitive statement there. June 23rd of 2024, court orders this is the court's order on the defense's motion to disqualify herself. I added this because I had not read it. I had not read it, and I read it, and I was like, I kind of felt irresponsible for not having read it before I spoke upon it. I didn't know it existed. So this is in response to the defense's second verified motion to disqualify her. And then they wanted to call her as a witness to something she was biased because her daughter went to her granddaughter played in a softball game at the part of the softball field. Just like it was a part of her tournament. Like so silly. So and where was a part? So this was about the guy that's in IDOC in Westville, Robert Baston, I think, if I'm saying his name right. But he was like supposed to show up and he refused to leave his cell because he felt like his life was in danger. And then the sheriff, like I guess it was Carroll County Sheriff. I didn't know that. I thought somebody was trying to transport him and he refused to go. And so they just like left him there and asked that, well, we'll just read it. The sheriff ignored a subpoena. The court directed an email to counsel on June 14th of 2023 regarding the witness refusing to cooperate with the court with the service of the subpoena and demonstrating a willingness to fight the deputy attempting search, so to pick him up and transport him to court. The court requested a report of the witness's refusal to cooperate and be transported for the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court. There was some past filings that claimed that she told him, well, if he's not willing to come, then, leave him there. So apparently that, I don't know. I just thought that was something that I hadn't read and I wanted to look into. The defense claims the court engaged in ex parte communication with the Carroll County Sheriff regarding the defendant's housing, transportation, and safety during jury selection and trial on May 13th through 31st of 2024. That's when it was originally scheduled. These communications were administrative in nature and did not address any substantive issues. The communications were directed to where the defendant would be housed during the trial, which definitely something the judge needs to have communication with the IDOC about and the transport team. Like, and then both of the state and the defense were like, hey, where do we have a room assigned to us? Like where we can go for prep? Like even McLeland was just like, he filed a motion like, what's the trial's like in 2 weeks, like a week away, 2 weeks away. Like we don't even know the basics of logistics here and like how things are going to be run. So I think she was a bit neglectful in getting those things out, but like her communicating with them is exactly what they were asking for. So that's weird. So counsel's claim the court invited the state to limit defendant's Sixth Amendment right to present a defense. The court has, because they shared her emails. The court has always required counsel in all criminal cases to follow the law relating to third-party perpetrators. So the defense was trying to say that she had basically like hinted in their private emails between McLeland and the defense that it said something like, something about, third-party perpetrators. And then McLeland like filed something about third party like right after that. So they were just like, hello, duh. Like he literally did that because you put the idea in his head in these emails. So the court, it's saying like she just reminded the counsel of their obligation to follow the law in the court's email on April 28th of 2024. Hadn't read that. This was the funny part where she gets a little salty. The counsel claimed the court has disparaged them and ruled on defense pleadings without hearings. The court comments about counsel's performance were documented in the court's order on April 30th, 2024. And she really did regarding their handling of discovery materials. If pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. And that's true. Allegations the court has treated the prosecution more favorably than the defense are unsupported by any, and this is important, any admissible evidence provided by the defense. So admissible. But it does, I mean, even it does seem like she's, kind of hand holding a little bit. She's not doing it as like much anymore, but there were some points and I'm just like, I don't know. But again, you got to always go back to these people know the loopholes of the law. She knows them. They know them. I think her and the defense know them better than the state, just from naivete and inexperience. But I guess apparently I mean, I'd heard this, but I never really looked into it, that McClellan was a lawyer, a military lawyer. So that kind of changes things, because that they're held to a pretty high standard, like as far as like military law and like lawyers go. But I didn't know that he did that. So the court notified on May 20th of 24 an inquiry by the Indiana State Police to the court reporter via email on May 9th regarding ex parte communications, because this is another thing that came up. McClellan read some, they're clearly marked ex parte, and clearly, like, we know what ex parte means, is like, this is just this is not for all eyes. This is just for the judge. And he read them because they were filed in the wrong way. Therefore, a loophole, basically. I mean, take it outside of Richard Allen. If this happened in another case, this is a loophole all the same, because of the way that they were filed. And the way, and because of that alone, even though looking at this, he should have known, you think, duh, like he should have known, there's still a law loophole here. The court is unaware of the extent of any Indiana police investigation. Naming a YouTuber. The defendant blames the court for ex parte pleadings, which were inadvertently directed to the prosecutor by the way that they were filed in the filing, third party, like filing, what's it called? Docs pop, like, is it docs? There's one in Indiana, like, that's not my case, but there's a way to, like, so she sent them, like, here's how to do it. If you're not familiar, I can't believe you guys aren't, you're seasoned defense attorneys. Like, I don't know how you didn't know how to file these. But the defense staff filed pleadings and marked them as confidential, apparently unaware that the confidential marking makes them available to the state, but not the public. Counsel staff contacted the court staff and were advised that the statewide Odyssey case management system, this not DocsPop as alleged in the pleading, because we have access to that, has a distinct process for filing pleadings ex parte as opposed to confidential. The court did email defense counsel a tutorial paper authored by JTAC, so the Odyssey, like, management, explaining the process. Since that communication, the defense counsel has had no issues with their staff properly filing ex parte pleadings. The loophole. The court follows trial rule 6 regarding time and gives the state 20 days to respond. So they're arguing about, like, her not ruling on motions. So trial rule, you can look it up. I might have it right here. Probably get to it. Now I forgot the trial rule. Nope. What does that say? Six? No. What am I doing? Jeez. Mhm. What if it's just like, no, it wouldn't even be that. I don't want the cases. Mm. This appeal presents the question of whether Indiana Trial Rule 6 extends the date by which the non-movement must respond to a summary. Oh, I know what this rule is, but I don't know. I'll have to find the definition when I'm not sharing screen because I'm just like not. But basically, because I know this because there was a case, McLeland, where it was in the appeals, but basically, like, this guy was already in jail, right? This is in the appeals court. Like, this guy was already in jail for another crime when he was charged with one that was like a pretty serious felony. I think it had something to do with children. And he filed like a what is it, pro se motion for a speedy trial. But he filed it with like he let a letter from the jail to the courts, and then like it was past the trial rule 6 date, and I'm pretty sure the case was dismissed because of it, you know. But obviously there's loopholes, and I don't quote me on that. I looked that up a long time ago. Anyway, let's just get back to this and stop wandering around. So this is the part where they wanted her thrown off, and then they wanted to like call her to testify for something that it was engaging in extrajudicial activity. So on July 9th of 2023, and they like filed this in a motion as their, proof that she was biased. The court commented on a Facebook post about a softball tournament her granddaughter participated in Delphi. The court did not attend the tournament, but did say congratulations to her former daughter-in-law's post so this would be her son's child, about their team winning the tournament. If counsel's allegations is that part of their movement as are well-founded regarding a potential witness alleged social media activities and are presented to the court for ruling, the court will rule accordingly. Concerns about anticipatory rulings are not reasonable. The defense attorney of the courts has denied reasonable requests for funding. This is incorrect. Counsel is well aware of the amount of funds the court has authorized for the defendant. The court has requested the defendant to submit proper invoices and bills for Carroll County taxpayer funding. Invoices which have been submitted without appropriate documentation have been returned. The bill counsel refers to for $26,000. This is right before, when they filed this, it was right before the YouTube live fundraiser that raised $40-some thousand for Richard Allen. He definitely couldn't get people to raise that amount for a mom to find her son when this monster's, killed him and dismembered his body and put him in 3 states. Couldn't raise a dime for something like that, but let it go. Submit proper invoices and bills. So they purport like he had, and Rosie should be paid. But if it's just a matter of like, you don't know how to fill out the proper paperwork and you leave it all blank, and like, it's not just her, there are there are like other people, you have to fill in the right columns, even if you misfile. I've gotten notice where I've accidentally like checked the wrong box on my taxes, and that ended up being an audit, like, it cost me, so many hours of time, all for one little tiny error before I hit send, because I do my own taxes and I have for many, 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 many years. Never had a problem. I just got careless and put the wrong entry line, data line in the wrong spot. And because of that, I got audited by the state of Indiana. I was just like, you've got to be kidding. That was a pain in the butt. So, this isn't like, it sounds horrible on the surface, but when you really dig into it and you think about it outside of that box of like, you're just like, duh. You have to fill the stuff out, right? There's other people that need the documentation, and they've hired professionals, the accountants and things. So that was kind of, and then once returned to counsel as no documentation was provided for the services. No documentation was submitted until quite recently. Without proper support and documentation, the court authorized that invoice for payment on May 17th of 2024. The defendant complains that the public confidence in this case is eroded. As counsel should know, criminal cases are tried in the court of law and not in the court of public opinion. An independent judiciary requires that judges decide cases according to the law and facts without regard to the public clamor or fear of criticism. Yeah. So this is the part about the media. The court has not allowed cameras in Carroll County's circuit court due to the limited size and layout, which I don't know. It seems kind of weak. The court did allow cameras in Allen County at the hearing conducted on October 19th. This was the one where the defense team had a secret chambers meeting. And I'm sorry, but that may not have been anything that violates the, code of conduct or like officially, because it did get sent to another court, like an appeal. And they didn't find there was any, they reinstated the defense attorneys, which is fine. That's good. But they didn't kick her off, which was what they were asking for as well. It was like the dual appeal, and they already ruled on it. The hearing was not conducted, and the media outlet providing pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. The court lost confidence in the ability of the media to cover hearings appropriately. Anybody out there know what she could be talking about? Because I didn't. Night, GP. Hey, Purple Puddles. Okay. So something that I wanted to look into farther anyway. Okay, so the state responds to the defense's motion to dismiss, just concerning her phone. It's just digital forensics. So this is the defendant's reply. This was on, so we're getting closer to these hearings right here, that just happened in the end of July 23rd of 2024. Things start to really heat up in these filings. But they're also very repetitive. In said request, the defense detailed newly discovered evidence, hereafter called the Blocher report, that suggests that the phone that was found at the scene where the victims of the murders were ultimately found on February 14th of 2017 had actually been taken out of the area on February 13th of 2017 before being brought back to the area at some point in time on February 14th. So they think this means that the victims were not there the whole time, basically. Which, I don't know. That seems like a jump. When the rest of the evidence doesn't support them dying at any time then shortly after they were killed. So it's just kind of a leap. The prosecution turned over the Blocher report approximately 14 months after, so we've already heard all of this. So they're saying that this completely throws off the state's timeline of events, which they've said, and thereby exonerating Richard Allen. I don't. So I am in the blue here, in parentheses here, just like I had to write down a thought. How does this throw off Cicero's testimony or the nibble of Dr. Cour's depot in the defense's memorandum of law that was filed on August 15th of 2024? They depoted him, Dr. Course. This is important because law enforcement has maintained from the beginning of the case that the girls were murdered on February 13th and remained in the place they were found from the following day, never leaving the area where they were ultimately found. This new evidence, therefore, would show that the phone and the victims were, so the phone and the victims, this is the jump, like I was talking about last night about supportive, evidence that supports a claim, were taken outside of the area and were ultimately found, but then brought back to the area at a later time. In his response to the fourth Frank's request, the prosecution makes several assertions that simply aren't accurate or true. The prosecutor is not a digital forensics expert. True. However, you could tell it's just a dictation, because when Edward says, those are all in there, he quoted from the depot that the state and the defense both have the depot from Sergeant Edwards. So that's, yeah, you're right. He's not a digital forensic expert. However, you did depose this guy after you requested it, and even stated, like, I get they're saying the judge turned them down for the money. And then they said something about the funds that they've raised won't cover it. And then they said that they shouldn't have to spend their money. They should be able to use the same, like the state's resources. They should be able to depose them and use them and at no charge, which I agree with that. So they did that. And then they just they in one ear right out the other with everything that Edward said. We read it last night. And his assertion should not be accepted as true or accurate by this court until he presents evidence and or testimony that supports his assertions. And then there was hearings held on this very thing. So that did take place. We'll read that here in a second. So this is, I don't know what I even thought about this. Did he give the judge the deposition of so did he, like, maybe not to the public, but did he file the part that he quoted from the deposition of Edwards that was transcribed? Clearly it was transcribed by somebody, to back up the quoted transcription from February 27th of 2024. So I started in March 13th. They had already deposed Edwards, right? Why did the defense not subpoena Edwards? I spelled that wrong. I can never spell that word right. Why wasn't Edwards in the July 30th through the August 1st hearings? No clue. Or better yet, their own expert. I do feel like another hearing may be in order on this issue because of the Cecil testifying, yet his newest analysis had not been submitted by the time of the hearings. I mean, I don't know, kind of makes sense to me. Similarly, the defense attorneys are not digital forensic experts as well, and therefore the defense would also request this court to not accept their assertions as facts. That is a classic line. That's classic for that good faith, bad faith, tit for tat. Rather, on such an important issue as to whether law enforcement failed to inform Judge Diener concerning evidence related to the timeline that would have indicated to Judge Diener that Richard Allen did not commit these murders, that's crazy. The defense would request this court to set a Franks hearing to hear both sides before making any determinations. Simply stated, through the pleadings filed by both sides, two competing narratives have formed. One, the state of Indiana disagrees with the defense interpretation of the digital forensic evidence and the Blocher report, while, number two, the defense disagrees with the state of Indiana about its interpretation of the digital evidence and Blocher report, which we can see in our own community here. Like we're reading these same documents and two different, intelligent, human beings have read them and they get two totally different interpretations of the same data. So we see that within our own little community here on a daily, with this case in particular and others. A hearing would allow the court to listen to the evidence, and they did. Even though it wasn't a Franks hearing, there was hearings still held about the motion to dismiss. There was already a suppression hearing held, but a motion to suppress and motions in limine. So this is Cecil's transcript. These were on a link prior to me messing about. I think that's it, but I better click off and double check. I thought I named it. That didn't matter. I didn't click off, did I? Okay. I found it. Okay, so this is First Sergeant Christopher Cecil. He was a state witness during the hearing on motion in limine on that was held on August 1st of 2024. And just for quick references, he's Indiana State Police. He's a first sergeant. That's his rank. He has been there for almost 20 years. He did special training and schooling to be a law enforcement officer. Yes, he did. Continuing through yearly training. He's a part of he's the commander of the Indiana Internet Crimes Against Children Task Force. And he has throughout his duties is occasion to take cellular phones or electronic devices, and he says yes, like this is something that he does, but not routinely anymore because he's the task force commander now. So, that's so. But he's asked the new analysis of Liberty German's phone, and he said that's correct. And then McLeland asked him, like, did you do one prior? And he said, yes, I did. I did one in 2019, and there was a report made about that one. And you decided to do a new analysis of it. So he did one here recently, like in May of 2024, I think, or maybe June. But he didn't have it. The court didn't have it, and they were waiting on it. Neither side had it. Or he had until October 1st, I think. He has until to get it to the defense in the state, this newest report. So why'd you do it? New tools, and then also technology's changed. So this was done in 2019. We're in 2024. I know from my experience that forensic software updates, gets better, and can find things. So we find out that there was several done in 2017. The 2019, they're using two different systems. One's called Magnet, one's called Celebrite. And you have to be able to analyze, like all of them in context of each other, about the analysis. So through that report, were you able to determine that there was a video on Libby German's phone taken on the High Bridge on the day of the murders? Yes. And this is a pretty famous video. And we know that it has Bridge Guy in it. Is that correct? And he says yes. And the Bridge Guy video that says down the hill, and he says correct. And then he adds to it, and he says this is McLeland. He's direct exam. And so that is the point where Abby Williams and Liberty German are abducted from the Monon High Bridge, correct? And Cecil says, my understanding, yes. He can't really testify to abduction. He's only, being professional and only giving, his analysis of what he was tasked with, which is the digital forensics. So another part of his testimony that I found important was McLeland is asking, First Sergeant Cecil, can you take a look at that report and tell me the time, if you can find it, when the video started on the Monon High Bridge? And he says, so the video starts on February 13th, 2017 at, I'll just read standard, like our time, like not the 2:13 and 51 seconds p.m. And was there a location or GPS location associated with that video? And he says, so when the video initially starts, the GPS geolocates kind of over near the Delphi High School. So distinct difference between Delphi High School and the bridge. But then within a matter of seconds, it comes back to the Monon Trail. That's where it goes. So McLeland asked, and were there pictures on the Monon High Bridge taken before the video? Is that correct? And he said, yes, sir. And were you able to recover those pictures? And he says, yes. And those pictures have GPS coordinates with them. Is that correct? And he says the pictures don't, but there are when Snapchat's being used. There are GPS locations when Snapchat's being used. And so there are pictures taken. So this is McLeland again. So there are pictures taken throughout Snapchat, and you're able to get a GPS location through Snapchat of those pictures. And he says, yes. And then he's asked, and they show that the pictures were taken on the Monon High Bridge and as well. And he says, yes. And then he's asking, were you able to examine the pictures in the video? That's correct. Yes. And in both of the pictures in the video, does it portray or does it show Abby Williams in the picture and the video? And he says, yes. And is she wearing the same clothing from the picture and what she was wearing in the video? So now we know for sure. We've always kind of known that, but Libby's infamous video has Abby in it, and then Bridge Guy. They cut her out, which was pretty kind of obvious when they released the actual motion video in 2019. He says yes. And is she wearing the same clothing? Yes. And so you're confident the video was taken at the same location and time as the picture prior to it? He says yes. So the time of that video, it starts at 2:13 and 51 seconds p.m. on the 13th. And when does it end? And he says it ends 43 seconds later. So 2:14 and 34 seconds. And then were you able to track movement on the phone after that? Is that correct? And he says correct. And through this, the internal function or the internal GPS of the phone, he says, well, it has to do with the Apple Health data. So this is what independently I researched and found. So Apple Health data from Apple Health says that it tracks your steps, flights of stairs, and other walking data. Built-in sensors on your iPhone capture the number of steps you take, the number of flights of stairs you climb, your walking speed, and more. Stride, that kind of thing. Mobility data. iPhone stores important mobility metrics such as walking asymmetry, double support time, and more. Over time, as you walk with iPhone in your pocket or wear it near your waist, these metrics are used to calculate and record your walking steadiness. You can browse this data in the mobility category. You can also receive a notification and share your notification with others if your steadiness becomes low enough to put you at increased risk of falling in the next 12 months. Whoa. Okay. So he says, it doesn't track GPS. So in the last slides, we went through all of the different meanings of all of these words and explain that. I'm not going to do it again. So just movement, not your GPS, like what's it called? Global Positioning System is what GPS stands for. And it is your latitude and longitude with the radius. So it gives a radius of where your latitude and longitude is, which is any given point on the earth. Okay. And so he says, nope, just movement, not GPS related. And he said, at some point, does the phone stop moving? He says, yes. When is that? And he said, so the phone stops moving, same date, February 13, 2017 at 2:32 p.m. and 39 seconds. He says, correct. Did the phone move after that time? No, it did not. And do you know how long did the phone stay on? And he says, it's my understanding from my examination, I'm currently still in the process on, it stayed on until sometime after 4:30 in the morning on February 14th. So the phone, Blocher report says that it wasn't when they were pinging it through AT&T because the girls were missing, pinged it every 15 minutes, and then they would send a report. And if the phone didn't move, it would show historical data. And then then it shows and so Blocher, like the man, the person who's died, he of nothing nefarious. It was cancer. Um, seemed like he was very loved, very well, high esteemed in not only in his career and profession, but in his life. It's really sad because he's like my age. It's like, wow, the family. It was just sad. But anyway, so do you know where the phone was ultimately found? And he said, my understanding, because remember, you got to be careful with, he's just been told this. So it's his understanding it was found underneath one of the girls. And he said, okay. They admit, and then now he's under cross-examination of OJ. We're going to go with that for today. Now this, I just found this funny. She says his name, First Sergeant, Cecil. How do I refer to you? And he says, you can call me First Sergeant Cecil. I don't know. That just made me chuckle because it was like, even McLeland called him First Sergeant Cecil. And she's like, what do I call you? And he's like, First Sergeant Cecil. I would have liked to hear like the inflection of that in the courtroom. She says, okay, First Sergeant Cecil. Now, you said earlier the girls were abducted at 2:14 on February 13th of 2017, correct? He said, I didn't say they were abducted. I just said that when the video happened. So she's trying to, get him to say, yep, but he didn't fall for it. Just like when McLeland did. He's like, that, to my understanding, that is what happened, just like he just did right here. And he said, to my understanding is it was found underneath one of the girls. So, because that's outside of his purview. He's tasked with this, but obviously he has some knowledge of this case. So he's like, to my understanding, yes. My understanding that, so she tried to get him and he said, no, not today. And so she goes, okay, you have no idea if the girls met someone they knew or what happened at 2:14 when the video ended, correct? And he said, I only know what's on the phone. So this is OJ. So you can't say that they were or were not abducted. He says, I can't say anything. You're right. And she knows damn well that he cannot testify to anything but the data extracted. Like, he can't say a definitive, yep, I know that for like a fact they were abducted. I know that for a fact where the phone was found. I know it for a fact. Like she knows that. This is a defense attorney. So begs the question, who is she talking to? Who is she suing all this for? Because it's not the judge. She's not going to trip the judge up on semantics. So if it's not for the judge, there's no jury in these hearings. So to me, the only logical conclusion is that it's for us. That's what a lot of these hearings were like. Who is this even for? Because this is so irrelevant to this hearing. So who is all this for? I don't know how you can come to any other conclusion than it was for us, the public. So then she brings up the Apple Health data. Did the Apple Health data show Libby German's phone moving from her home over to the location where they got out of the car and walked onto Modon High Bridge? And he says, I'm not sure I understand. Like, he was like not understanding what she was asking, which was the confusing question. And so then she clarifies, like, it doesn't necessarily show movement if you're in a vehicle traveling down the road, correct? So then he says the only way it could is for some reason, I guess there's like a thing, and I have this with Life 360 too, even though it's totally different from health data. um, is if you like went over a bump. If you're driving and you go over a bump, it might record like something right there. Like it might keep a record of that. Okay, so it doesn't show any movement of Libby German's phone leaving from her home. So walking to the car, getting in the car. Obviously, it doesn't show when she's driving, but then she like did walk quite a way. They get dropped off at Mary Gerard. They walk down around the trails and then end up. I think they got dropped off at 138. Correct me if I'm wrong. Hippie, was it 138? Hey, Gonzo. Good to see you. So, and then the video is taken at 2:13, and like I've walked from Mary Gerard. Well, I'm not. I've jumped out of perfectly great airplanes a few times, like 2 times. I've gone cliff diving. Like I like jumping off of things, and I like extreme sports. But hell to the no. No, I wouldn't walk across. I know other people do, but when I was there, it had rained for several days before that. So yeah, I did take that into consideration. But when we were there looking at the bridge, and I like grabbed some of the tie, and it came off in my hand. Like it was, I know what dry rot looks like. I'm in the woods enough to know. And these were dry rotted, these railroad ties. Like, hell no, I'm not walking on that thing. And my depth perception is terrible. So unless I have a parachute on or a bungee cord attached to me, I ain't doing it, because I'm more than likely to be the one that falls off that thing and dies, because I don't have, I trip over my own toes. But yeah, no. Mm-mm. But I still like, it doesn't take that. My point is like from 138, 138 drop off to 2:13 when the video starts. It does not take that long to get to that point. Now, the only thing is like I believe that we were told this by both families of the victims, that this was Abby's. Don't take this as a fact, because again, this is just stuff gathered over time from being around in this case. Hippie helped me out on this one too, that this was Abby's first time, because there was a lot of speculation in the groups of how in the world could it be her first time, because she's got her hands in her pocket. My rebuttal to that, like I said, I don't have good balance. I don't have depth perception. I run into things. It's just a thing I've had since I was born. I don't know what it involves, why, but it's something that even like I've had been tested, and my daughter also has the same issue. Um, so, um, but I do know, like, when I'm hiking, and a lot of times you'll find like really cool fallen trees, and I'm just like a big kid at heart, and I want to walk across them. And because I don't do balance beams well. I have a horrible balance beam story that will just make you guys all cringe, so I won't tell that right now. But if it's big enough, and I think of like, okay, I probably wouldn't break anything or die if I didn't make it across this. But one thing that I do is put my hands in my pockets when I walk, because it does help steady you, and like I can see where it can be her hands are in her pockets, so she looks more relaxed. And I'm just going off of my experience when I'm on things that I know I shouldn't be, because I don't have depth perception or balance. But it does help. Try it. Like, prove me wrong. Like, you can try it yourself. Walk across something with a jacket on that has pockets and put them out. I do it in a sweatshirt, like not really a sweatshirt pocket, but in a jacket, which I wear a lot, and you put your hands like that in it, it does help with your balance, at least for me anyway. I mean, that's just my perspective. And I do think it's weird that it didn't show any data, or he's not aware of it. But he says, no, it doesn't. So you're referring to Apple Health, correct? And she says, yes. And he says, no, it doesn't. She goes, pardon? It does not. The Apple data does not. Okay. Because it doesn't necessarily pick up if you're in the car unless something kind of significant happens. Is that right? And he says, right. But this was such confusing testimony because it's like, is it the way that, like, the semantics of it? Like, he's answering her truthfully, but we still don't really know the answer to, did it record steps or not from Mary Gerard to the bridge? Because if it didn't, that's super weird. I'd be focusing in on that. She says, okay, because it doesn't necessarily pick up if you're in the car unless something kind of significant. And so he said, right. Like if you hit a bump, which he said that earlier. Okay. Are you familiar with the area around the south end of the Monon Bridge? I just really feel like she should have paused here and made him say, like, definitively answering, not a doubled question up with vehicle and the movements after, not in a vehicle. So the movements from the house, in and around the house, to the car, and then obviously it's not picking up driving in a car. It can tell the difference. But she got out of the car and she walked to where we see the video. Apple Health data didn't record anything right there. That's why I feel like she really she missed a important thing to really. I found it odd because she does, like, dig in on certain things and it's very repetitive because she keeps getting, she's, but on this one, she's just like, she didn't really ever. So the cell phone tracks movements. Correct. It shows movements when people walk. Yes. It doesn't necessarily show. So it's like the whole thing was just kind of, okay, now the ability to track movements of the phone, you said, came from Apple Health data. Yes, ma'am. Okay. Apple Health data. Does it show Libby German's phone leaving from Libby's home? So she's asking this. She should have just stopped. To the, do you have a map? Like, I don't think she even knew how to ask, but she should have just asked, does the Apple Health data show Libby German's phone, for her walking to the car and from where she was dropped off after the car stops moving on the trail, down Mary Gerard, then down the trail that the bridge is on. I never remember if it's 505 or 501. They don't stay in my brain. So she should have just stopped right there, but she didn't. She says, okay, did Apple Health show Libby German's phone moving from her home over the location where they got out of the car and got onto, walked onto? So she does ask the question, and he says, I'm not sure. I don't understand what you're saying. Well, you said the cell phone tracks movements, correct? Correct. And it shows movements when people walk. Yes. It doesn't necessarily show movements if you're in a vehicle traveling down the road, correct? He says the only way it could is if for some reason it would detect that's the bump thing. Okay. So it doesn't show any movement of Libby German's phone leaving her home to the trail that day when they were in the vehicle, correct? Like, again, it should have been the way that she formed the question leaves me in question. And he said, are you referring to the Apple Health data, correct? She says, yes. He says, no, it doesn't. But again, instead of just saying, does the phone show her walking to the car? Does the phone show her walking to the trail? Until the point where the video starts? But she doesn't really definitively ask that because that's not the point she's wanting to get here. But I think it was a point that she really kind of missed. She missed the mark on it. And she says, "Pardon?" He said, "It does not. The Apple Health data does not." Does not what? Because she keeps, talking about the movement because that's really her main. You'll see that here in a minute. That's what she's wanting to get him to trip him up on. But she says, "Okay, because it doesn't necessarily pick up if you're in a car unless you hit something soon." He says, "Right. Like if you hit a bump." Okay. Are you familiar with the area around the south end? So now we're moving on. Now we still don't know the answer if there was Apple Health data that went from from getting out of the vehicle when Kelsey dropped them off to getting to where the video was taken at 2:13. So from 1:38 to 2:13, Apple Health data didn't record any steps. Or did she just not ask the question and he didn't offer up the answer? We don't know. So question mark on all that. So now that we're getting to what she really wanted to hone in on. And he says, "Are you familiar?" He asks, he's like, "No, I've not been out there. I'm not, just from what I've heard on the news." Like he's not familiar with, much more from the south end of So she asks, "Oh, are you aware that between the south end of the Monon High Bridge and the location where the bodies were found, there is an access road?" Which, so actually it's a private drive, but I guess access road. But it's not. It's not. It's an access road to the houses, but it's not like it's an access road to the like bridge or something. Um, and he said, "I did not know that." And she says, "And the Apple Health data, the number of steps and the distance could have gotten those girls to somewhere on that access road. Is that correct?" He says, "Not necessarily. But it's not wrong, it's not right, you just don't know." He says, "Correct, you're right, I don't know." It's a possibility? So she's trying to make the point that they were told to get down the first hill from the bridge because they're divided up. So you have the bridge, there's a hill, and then there's the private drive, and then there's another hill, then there's the like a little clearing type area, and then there's the creek, and then there's the other side where their bodies were found. So she's trying to make the point that they were on this access road, so therefore, but she didn't really like make him answer her first question. Would have showed grounds for this one. Am I making sense to people? Because he never really gave an answer to whether the Apple Health data recorded her walking around the house, walking to Kelsey's car. We've established it doesn't log riding in a car information unless you hit like a bump or something, and it might show a blip. Otherwise, it's not going to record anything. But then Libby gets out of her car. She's still got the same phone. So we don't know because but she wants to prove that it's a possibility that because the Apple Health data didn't record Libby getting in Kelsey's car and the ride to the trails, that they could have been abducted from the access road and then driven in a car. That's what she's really wanting to ask. She's just beating around the bush about it. But like the significance of it would have been much more significant if the proper questions were asked and answered, but they weren't. So maybe they will be later. I don't think they ever were. So she gets this exhibit, and it's a hand-drawn map. What the heck? Why is exhibit QQQ a hand-drawn map of the area? That is just the weirdest thing ever. Hand-drawn map of the area where the bodies were found. And so she shows it. If you can you see this area here? And he's like, "Yes, ma'am." And we highlighted that. this hand-drawn map, and they highlighted this as an access road. And would the Apple Health data get the girls somewhere on that access road? Do you know? He said, like on a specific point. Are you asking me like GPS point? Because he's already established this is not GPS. Any point. If they walked this distance and this many steps, could they have ended up on this access road? Correct. So that's kind of a tricky way to ask a question, but a good lawyer way to ask a question. He said, so Apple Health data doesn't collect, it doesn't track GPS. And she says, no, it doesn't. I'm not asking you for a location. I'm saying if we start the number of steps that you've measured, have you measured any of those steps? He says, no, I haven't. Okay. I mean, I don't know who I don't know which girl could have been carrying the phone. Because like I read up here, like it'll keep track of your stride up here. It'll keep track of that. So he's not measured the actual steps. And then he brings up that for all he knows, Libby could have handed her phone to Abby, and their strides would show up different based on their height, based on their gait, their, cadence, all that stuff. And he says, as I mentioned in my deposition, if you're carrying my phone and then you give it to me, you may walk different steps. So he's already been deposed, Sure. And the steps are more accurate than the actual distance that the iPhone reports. Would you agree with that? He says, I'm not sure. I've got that written down in my notes, but I don't recollect that right now off the top of my head. She said, okay. So she's like, no, you're fine. It's a tough one. Like, to answer your question, I'm my research for preparing for this other examination. So this depot, I'm assuming, both of them are going to be correct. According to research that's been done by other police officers who've wrote a white paper on this. I don't know, like, is it named white paper report? Like, I don't know. She's like, okay, so the distance will be as accurate as the number of steps. He said, from this research that's done by another law enforcement officer out of Europe, because I have the paper, it's part of my research that I've done for this. Now he's saying this examination. Okay. And just to be clear, your testimony is that the distance traveled will be as accurate as the number of steps. He says, I'm not saying, I'm just telling you what I've learned. I'm not saying that I know that for a fact. I do not know that for a fact. Okay. And would you agree with me hearkening back to your testimony 2 minutes prior? If one individual has a different stride, he said, correct. Then another one, then this number of steps would be different than the amount, the distance traveled. Correct. Now, your gray key report that you did in 2019 on your report that you did in 2019, do you recall that? He's like, you mean my written report? Like, well, I don't think he called it gray key report, but it is a term that's used in those. That was a double homicide, right? And he says, yes. She says, I'm sure you give attention to everything you do. He says, yes. And so she asked them to please look at like page 10, the last line. And it says something about Liberty German and a little notation there. And I don't know, it says 38A158. I just underline it because like, what's that? What is that? And he says, yeah, tidal 38A. So it's a picture of the Monon High Bridge. She's at he said, she's asking him what it is. She's showing him an exhibit. He said, it's a picture of Monon High Bridge. And it's a picture that was uploaded to Snapchat. And the picture is just like somebody would be standing like in front like you're getting ready to walk across it. So we know what this is. This is the picture Libby took that she uploaded to her Snapchat. I'm going to show you what's marked as defendant's exhibit. Well, sorry, defendants of SS. Okay, so now this is is there a phone or a picture that you have learned of? Is there a phone or a picture? So big difference between like, is there another phone? But then she has or a picture that you have learned of that you could not find on Liberty German's phone. And he says, yes. What was that? That was a picture of Abby Williams walking across the bridge, and it's kind of taken off, like off at an angle. And that was posted on her Snapchat account. And he says, so my understanding from social media is that's what it was. I was asked to try to see if I could find that by the investigators, and I could not find, and she says, and you could not find that? He said, I could not find it. Now, so this is the picture of Abby on the bridge I was just talking about with her hands in her pockets. So my understanding is that Libby took the picture on her phone of the bridge and uploaded it from her phone to Snapchat, but she was in Snapchat in using the app when she took the picture of Libby or of Abby on the bridge. Therefore, that image would not show up in her actual album, her phone images. I just did this not with Snapchat, but with something else. I thought I had taken pictures, and I didn't realize that I had to save them from that app into my camera roll in order for me to still have them. So now I don't have them at all because they're not on the app that I took them on, which was like really upsetting. But you see what I mean? It was the magnifier, if y'all want to know. I thought I had a tonsil stone. Was convinced of it. I still kind of am. So I was trying to look for it, and I took the magnet out, and I had the flashlight on, and I zoomed it in on my tonsil to see if this was a stone. And I took these pictures of it so I could look at them after I was done probably doing something I shouldn't be doing in my own mouth. And then when I went to look at them, they weren't there anymore. And I was like, I know I took them because I looked at them briefly to like make sure I got good pictures of both sides. And then I went to show my daughter and they were not there. And she was like, Mom, you have to save them. I'm like, okay. Anyway. So remember, she's like, you pay attention to detail, right? Like, like this is a double haunt. He's like, yes, I do. And, try to be accurate and all that stuff. And so he's like trying to get him. So the last line on February 13th of 2017, at 22:32:26, I wrote, last recorded data received by iPhone. The iPhone battery was likely depleted. So, that's what he wrote, likely depleted. And she asked, and what was the last data you mean you received? He says, I'm looking at the data for that day. And this, as I testified in my deposition, this was a mistake. I made a mistake. I didn't calculate other things. I wasn't looking at February 14th. So he's admitting that he made a mistake. Prove the bad faith on that one. Not going to happen. Okay. And she says, okay, but even if we don't look, so what you're saying now today, when you said on May 15th, is that you don't believe the phone's battery was likely depleted. And he said, right. And she said, okay, but did you also make a mistake when you said last recorded data received by iPhone? And he says, yes, I did. I made a mistake. Okay. Did you say that? What data were you referring to? He says, if you look at the next page right here, when I talked about it, it says, quote, after the phone, it stopped recording. Excuse me. Yeah. It continued to function, meaning it was still powered on. I found no evidence that the user physically interacted with the phone. So Libby, nor Abby, nor anyone else, the killer, anyone else physically interacted with this phone, which I get in trouble with my family all the time because I perpetually put my phone on silent and I don't interact with them in a timely manner and they get mad about it. The phone continued to receive iMessages, messages, FaceTime calls, mobile calls, and other similar communications. Now everybody's looking for them. In addition, several applications updated in the background. The activity continued until the phone battery was depleted. Quote, end quote. That's what I put in there. That's what I was referring to. And so she's like, you know, were you referring to a peculiar piece of the data that you believe the phone received at 22, 32, 26? And he said, I don't remember. I don't know. Would you agree with me that that an iPhone receives data in different ways or messages in different ways? And he's like, that's very broad. You're going to have to narrow that down. This is very broad. And she said, okay, well, because she's one, like, I just want to be like, oh my God, get to the point. So this is about SMS, which I give you those definitions of. So this is like, there's iMessages. So like if you have an Apple device, everybody that has one or knows somebody that has an Android, you immediately know that you're not texting someone with an Android. The man in there, his doesn't even have FaceTime, so his show up in green, not blue, so, but instant messages and SMS messages will still they'll still come in. iMessages will still come in through a cell tower, through an SMS type message, but they're short message service. Do you agree that that's what that means? And she's like, and that's transmitted by a cell tower. Is that right? He says, he didn't know a whole lot about cell towers and how they're coming there. Okay. I feel like he should know something about this, but okay. Maybe they have a cell tower expert as well that didn't testify. Hey, Johnny. We know Kelsey was seen on camera leaving around 1:49. We know she had already dropped the girls off by then. Reed states response to the fourth Franks. McClellan changes the time to around 1:30. Yeah, I read some of the fourth Franks, but I don't think I just did the geofence stuff, but wonder why he would do that. Oh, so around and 1:49 is, I don't think that's really, you know what I mean? Okay. So it could come from a cell tower, and it could come from the Wi-Fi there. There's other things it would come from. He was like, that's what he said. And he said, okay. And she says, well, how does an iMessage get to a phone? He says, over cellular, or it could come from the internet. So if you're connected to Wi-Fi, if you don't have a cell phone service, like your provider, if you're on Wi-Fi, like you have, like I have 5G, even though I feel like it's totally not 5G, like 4G. That's like when my phone isn't connected to my home connection, my own Wi-Fi, like when I'm just out, like driving around, I'll be on like my 5G. So, but if you text someone that doesn't have an Apple device, it's still going to let you know the difference. But they can do both. So an iMessage can connect to a tower, or it can connect to the Wi-Fi service. But when you're interacting with another phone, it's my understanding that SMS is like from, like that is um, I don't know. I better not even say that on. So it's your belief that Libby German's phone was connected to Wi-Fi. So Wi-Fi now between 5:44 on February 13th and 4:33 a.m. on February 14th. He says no. And she says, and if it's not connected to Wi-Fi, the only way it can receive an SMS message is through a cell tower, correct? He says, yes. Okay. And do you agree with me if LG's cell phone receives 0 SMS messages between 4:06 p.m. on the 13th and 4:33 a.m. on the 14th of 2017? He said, I'd have to look, and then it takes a long time to find his report. And then she admits an exhibit, and then Latrell pops off. It's just like, what was the first time? So she's asking him, and then Latrell like interrupts. She's like wanting to know if the SMS message did the phone receive between 4:06 and 4:33 a.m. PM on the 14th through 4:33 a.m. on the 14th. And he was like 4:40, and and Latrell says, "What was the first time?" I don't know if he just had like an outburst of like just let me ask your questions for you. I don't know. Like it was just weird that he popped up all of a sudden. And he says 4:06 and on the 13th and 4:33. So you said 4:06 to 4:33. He said yes. So there's nothing at 4:06, but at 4:33:31 from what Magnet, this another forensic software program, is showing that there is an SMS message or 9 messages as it's referring to. And then she's trying to trip him up on the amount, like they're impeachable because it's a semantics thing with 9 messages and 15. Because he says that they're duplicates because there's some of them are iMessages and SMS messages, and they're duplicates of the same exact message from certain people. So 9 out of the 15, I didn't understand why this was the 9 or the 15 was what we were focused on here, but whatever. And she says there's 15 of them, isn't there? And he says some of these may be duplicate because it'll show up as an iMessage, and it may also show up as an SMS. So it may be the same person. Like, what is this? What is this cross-exam even about? I was just like, what is happening here? Because this goes on, I was like, okay. So then she shows him exhibit TTT, and and he's like, this is from Celebrate. And he was like, yeah, this is from Brian Bunners. So another name we're hearing now. And it was in 2017. And he's like, I'm not going to be familiar with this because this isn't his report. And so like, she's, whatever. And then McLeland interrupts, and he's like, Judge, if this helps, the state's willing to concede that there were messages that came in on 4:33 a.m. on the 14th, and the court can consider that if that helps move things along. Like, I'm satisfied with that. Like, the state taking a loss here and saying, yes, there were messages that came into Libby German's phone at 4:33 a.m. And he's like, I don't know that the specific number matters, but the state's willing to agree that messages came in at 4:33 a.m. on the 14th. And OJ says, I think the number is important, Your Honor. And of course says, okay. So she says, I'm looking at this magnet. Okay. And proceed. There's one call. He says there's a call that came in. But that from the Celebrate, because now he's reviewing somebody else's work product. Then he's saying that Magnet didn't parse this, which just means it didn't take a record of this. This is why they do a bunch of different ones. He said, I'm not looking at it with Celebrate. And she says, okay. And he says, so line 3, whatever she's showing, says the victim's grandmother's name, who was her legal guardian at the time of her death. For some reason, that entry is not here. So it's in Celebrate. It's in one, but not the other. Like, they're done confused me. And so she presents defense's exhibit TTT, and he's like, okay. And shows 15 SMS messages on Libby's phone. And but you're saying that you think that number 3 didn't go through for some reason. And in fact, that box is blank, and it says, what does it say there? And he said, so what I'm saying is Celebrate may have parsed it. They may have added it to their data collection. Because again, you're going off something that I didn't do, but he's looking at Brian Bunner's report. But actually, when I'm looking at it with a completely different separate tool, it's not showing it here. So I would have to pull up Celebrate and compare it to see if Celebrate parsed it. And because she's showing him an exhibit from Brian Bunner's, but he's done his on Magnet, Axiom. So received at least 14 messages now. So now we've conceded to the phone call, and now we're down to 14 messages, and he's like, yes. So okay. Well, so weird to focus on that. I don't get it. So it goes on about that. So Celebrate or Magnet. So from what Celebrate, he's like, from what Magnet is showing here is that on February 13th of 2017 at 10:42 and 22 seconds PM was the last SMS message. She said, okay, would you agree with me that the defendant's exhibit TTT does not show that SMS message? And he's like, it's only one page. So, I mean, it would. Those are, well, would you agree with me, sir, that those are in chronological order? And he was like, well, they're in reverse chronological order. But she interrupted. She didn't, but yes. And so it shows this is 4:47:30 PM on the 13th. And she moves to put it. So your data is even different than Brian Bunner's data from 2017. Is that right? Yes, but I know why. She said, okay, why? He said, because Brian Bunner, after he did his exam several days later or weeks later, he connected to the network to do an iCloud dump of Libby German's phone. This is through Celebrate, which would have automatically brought some of this data there. So that is the reason why this is here. Apparently there's a 1040 something SMS that came in as well. So he's like, she's trying to get him again. It's like so those are timestamped by the phone as of the time they are received by the phone, correct? He said, what Magnet and Celebrate are doing is they're pulling, as if you look right here, and he's trying to show her, and she's like, that's not my question. He said, it's pulling it as it's how it's sent. Not my question. Okay. When an SMS message appears on a cell phone, it appears timestamped as the time is received by the cell phone, correct? He said, no. And he's trying to give her an example, like a personal example. I just had my phone in airplane mode and received a text message, and it was sent. I received it. When I opened it up, it showed me when my daughter sent it to me. An SMS message. And he said, no, an iMessage. He's like, okay, those are different, right? Yes. But he says same thing. An iMessage is timestamped as the time it's sent, correct? I don't I fail to see the significance of that, but it seemed to be really, really significant to the defense. Um, and then, like, through the tower in Liberty German's phone is not connected to Wi-Fi, correct? No, right. It's not. Um, they can come through the tower because you're on the internet. McClellan tries to object. I guess I just like, can we make her, like, the defense attorney, Miss OJ, do an offer of proof or show me how this is relevant to whether or not third party can be talked about at the trial? The state called him just to establish the time of the video because he's the state witness to cover the alibi of Mr. Holder and the other people. Oh, I missed something right here. The state called him, so they called First Sergeant Cecil him just to establish the time of the video to cover the alibi of Mr. Holder. Okay, never mind, I didn't miss anything. And the other people that they wanted to name as third party. When you receive a text messages, I don't see the relevance, Judge. Your Honor, the relevance is, I think that Mr. First Sergeant's gonna get there. Yeah, if you'd move it along. It's in his deposition if we need it. An SMS message is timestamped as the time it's received by the phone, and its iMessage and iChat is timestamped as the time it's sent by the other phone. And so the relevance is, even though people were sending Libby text SMS messages, she did not receive those until 4:33 in the morning, meaning her phone is not connected to a tower between 5:44 on the 13th and 4:33 on the 13th. And then it suddenly connects at 4:33 a.m. on the 14th. And he said, I would agree with that. So its relevance is, he said, I would agree with that. Yeah. So, okay, thank you. And it's like, okay, so the relevance is something changed at 4:33 in the morning to make that cell phone. And the court says, well, why didn't you just get to that specific point then? Well, I'm sorry, and the court, like, you're dancing around the field here, because I'm wondering as well, like, what does this have to do with the third party perpetrators that you are alleging? Even though I think they all very well know, because of everything that we've read going back and forth before this testimony. And she's like, okay, well, I believe it was Jerry Holman testified that they had no evidence that Mr. Ellen went back to the crime scene after 3:30 p.m. on the 13th, is what that should say. And that phone, it was under Libby's shoe. The phone was under the shoe, and they're both under Abby's body, according to the state. And the phone didn't move after 3:30. And the court says, okay. And so she says, okay. And our point is that something changed at 4:33 in the morning, that it suddenly connected to the tower. And she says, this can answer that for you? He just did. Okay, then move on. Thank you. It was just really weird. So she finally just says, fine, like, I'm just going to let Mr. Baldwin make this argument and save the rest for trial. So Baldwin was the one that they did opening and, like, statements. I think they did closing, like, summaries. I guess they were, like, really long, but it was basically summing up all their points. So he was going to make that a summary and then save the rest for trial. She's like, okay. And then it redrags and he's like, I'm done. And then, that's it. But it was just a strange little thing. And then people were, like, all hyped up about this. So before I actually had the transcripts, I was like, oh, like, wow, like, but then I was still struggling to find the relevance of the definitiveness that people seem to have with this phone being the key to overturn the Cecil testimony, like, First Sergeant Cecil's testimony and Dr. Core's testimony. Like, I just don't think the phone usurps that, regardless of whether it was brought back or not, and like put under there, like that doesn't make any sense either, that would happen. But I don't see how they definitively, this phone, because it didn't move, and then all of a sudden messages come in at 4:30 in the morning. Like, how do you get to the jump to be like, oh my gosh, this is irrefutable evidence that third party actors they did this crime? Because Jerry Holman said that Richard Allen didn't go back. So his phone didn't travel back to the crime scene. Therefore, like, he didn't take this phone back there, which also at the same time means the bodies of the victims back there and then do all that with them. Like, that makes absolutely no sense. Like, I don't know who can get down with that. But like, the only part I could get down was like, if somebody, it could have been Richard Allen or the killer, or like why is that coincide with like somebody brought that phone back out there and put it under there for whatever reason they did, but that's not when they actually died. Why is that? Well, it's because they're wanting desperately to disprove the alibi of Brad Holder, and they must think that like they don't have evidence of where he was at 4:33 in the morning. But they have Holman saying that, like, I guess he's saying that Richard Allen's phone never traveled back. So is that inferring that his phone was active before out there, and then after a certain time, like, he didn't go back there for, like, his phone doesn't show him going back there, but so that leaves, well, do they have phone data from his phone? Because they named a specific number in the search warrant, and they also had other phones and devices, anything electronic that they could find. Same thing they did to Ron Logan. So here's a big question. Why and how did the phone connect? Yeah. And you would have thought it would have been of utmost importance in these motions in limine for that to be established. But again, because, I think they're if they hadn't run when the technology like updated for Sergeant Cecil, for him not to run it through again with the software updates and the technology from 2019 to 2024 advancements, I feel like that would not be doing due diligence on your investigative to stop doing that. I think that this isn't adjudicated yet. So it wouldn't have been doing a proper investigation if he hadn't have done the newest update. But it wasn't finished at the time of these hearings. So did the judge see it before she made her ruling? And, but that's like not even really what the geofence stuff was about. Because that's a whole different thing, that he didn't testify to anything geofence. That was Sergeant Kevin Horan. And for some reason, the state didn't want that one transcribed, which makes no sense. Because, like, they never established that very thing, which was what the purpose was of these, and they didn't do it. But, I mean, they've been given offers of proof. Yeah, the 3 reports, I guess we're finding out now there's been 4. So there's 2, 2019 and 2024 for Cecil. And then there's the Brian Bunner report. And then included in that celebrate was also the iCloud dump. And then there was the Sergeant Blocher report. So there's actually 4 that have been done on the one phone. So, that's, yeah, I don't know. But it's late and I have to get up early tomorrow and I really wanted to finish this. I'm just not a fast person. So, yeah, I'm not doing all that tonight. So it'll just probably be like an hour long live. I'm going to try to do it tomorrow night or Wednesday night because I really just want to finish something I start. I need to be better about that as like a personal growth thing and like not be just being on here for, you know, and then not being on here again for 3 weeks. And then being on here again for a few days and then not being on here for a month. Like if you look at my content over the amount of time that I've been here, I have way less content, whether you call it content or not, in lives and videos than most people. I have like a fourth of the content. And it's because I'm inconsistent. So boring as hell, whatever. I'm still going to finish this. Somebody hold me to it if it's looking like I didn't schedule it for at least the latest of Wednesday. Because, like I've said many times, nobody cares about the truth. I don't care about the like nitty gritty details. And I get it. I love a good summary. But we've also been hearing a lot of people complaining about the media who are trained journalists summarizing the stuff. So you just can't win for losing. But hopefully there's somebody out there that will listen to all this and like, you know, it'll help them to feel more confident in their stance, period. Regardless of where that stance is, they will hear this and they'll be more comfortable in their stance. Do you notice what I did there? It's like what the lawyers do all the time. You can infer that I said that I'm referring to like changing people's mind from the Free Allen crew, but I didn't. That's not what I said. I just said to, you know, like that statement was I could mean everybody, which is what I mean, but that you would be more confident on wherever you want to land on which extremist group you want to be in this community for this case. That's the part that makes me mad, is that it's been turned into a Delphi sphere, like the manosphere, like the drama sphere, because of people, you know, being swayed by some other person with a camera and a microphone in their bedroom or their closet or with a green screen. Like, that's not silly to do. Okay. Yeah. Yeah. That, and I like it. I read it as so there was a Brian Bunner report and he then like it was like a continuing things in those first 3 weeks, and then he added the iCloud because the iCloud is a copy, you know, of your data. So he added the iCloud data dump from her cell phone to do, because remember the maybe Bunner did the report before they even had physical custody of the phone, you know, because a lot of this is referring to what was done while the girls were missing. So it could have been that's when the data dump was done. Hey, Alan the Prowl. I'm getting ready to go, but thanks for listening in. Be safe out there driving. And thank you all for being here. Again, those of you that have my email and messenger, like give me a hard time if I try not to go live about finishing this little bit that I have left. I give you permission to rake me over the coals. Okay, good night.